Right now, though, I want to welcome to the show Breitbart legal contributor Ken Klukowski. Ken, how you doing this evening, sir?
Cam, always great to be with you.
Hey, listen, glad you could join us on the program tonight. Your latest from Breitbart, Fast and Furious, why Eric Holder will lose the legal fight. And you say that federal courts could soon step in to decide whether or not Eric Holder needs to comply with its congressional subpoena.
That's right, Cam. When what you have here is Congress has a constitutional authority to have oversight over the executive, so they can call members of the administration before them, everyone except the president and vice president, and put them under oath and ask them questions. Now, of course, obviously, terrible, terrible things happened, including the death of federal agents because of this Operation Fast and Furious. So this is a perfect example of where Congress is exercising oversight to say we're going to pull in everyone who has any connection, and we're going to find out everything. We're going to get to the bottom. On the flip side, the executive branch is constitutionally entitled to keep certain things secret, and that's called executive privilege. Now, it's normally like, military decisions, foreign diplomacy, the kind of stuff you write spy novels about that everyone kind of understands would be problematic if it was all over the news.
Right.
When those two things I just said, Congress's power of oversight and the executive's privilege to keep certain things secret, whenever those two come into conflict, eventually it goes into court, where the court decides who has the more valid claim. You start out with a presumption that Congress can get information, and then the courts look very carefully at whether what's being requested or demanded by Congress falls within this narrow area of what's called executive privilege, and that's what's going to happen with Operation Fast and Furious.
Okay, so, and you lay out what has to happen first. First, the House Oversight Committee has to vote to hold Holder in contempt of Congress, and then it goes to the House floor for a vote. Is a simple majority all that's needed?
Yes, simple majority.
Okay, and that's when the courts would get involved. Then it's handed over to the U.S. Attorney's Office?
Well, that's right. Prosecuting someone is a pure law enforcement function. So at the federal level, that's the U.S. Department of Justice. So in this case, you have the very awkward situation that the U.S. Attorney, who answers to the Assistant Attorney General over the U.S. Attorneys, who answers to the Associate Attorney General, who answers to the Deputy Attorney General, who answers to the Attorney General, that U.S. Attorney will be making the decision about whether to throw the aforementioned Attorney General in jail. And that'll probably be a pretty easy decision for him. It's going to last somewhere between a tenth of a second and half a second, and he's going to say, I'm not going to prosecute this case.
Yeah. Okay. So, so what happens then? I mean, if as you say, you can't have DOJ, investigating DOJ or attempting to prosecute DOJ.
That's exactly right.
So what's the next step then?
So at that point, that's when Congress, if they pass another resolution, if they would, I believe, that if the full U.S. House then votes to say, okay, the executive branch isn't going to do it, we want to take it to court, then Supreme Court precedent makes clear that individual members of Congress do not have standing to bring that kind of a lawsuit. Only Congress acting institutionally can do it, and everything Congress does institutionally is done through a majority vote, that the full U.S. House would then have to vote to allow the head of the investigating committee, Darrell Issa, authorizing ISA to file a federal lawsuit on behalf of the U.S. House seeking a court order from a federal judge demanding and requiring Eric Holder to provide all of these tens of thousands of pages of documents that right now he is refusing to do so. The withholding that right now is leading to his soon-to-be held in contempt of Congress. And that's where Holder will say, no, I don't have to, because it's covered by executive privilege. And that's where the court will make the determination, looking through 200 years of precedent, as to whether executive privilege applies. If it does, he can keep his mouth shut. If it does not apply, he has to spill the beans, open the vault doors, show us everything that's in there.
And you say you don't think it's going to be close?
Yeah, it's going to be a slam dunk. It's there's as I mentioned briefly in in the column. This is an area of law where I've actually published a scholarly publication as a law school faculty member.
Yeah.
There are two types of executive privilege. One is the presidential communication privilege. That is a core constitutional power, but that only involves the president. The president is the head of the executive branch, and so it's the private conversations that the president has with foreign heads of state, with his national security advisor, with his generals if he's prosecuting a war. It's the kind of stuff that covers that. Other high-ranking members of the executive branch, if the president is not involved, they have a much weaker form of the privilege. It's just called the deliberative process privilege. It doesn't take all that much to beat it. Now, there's different factors, like if it's foreign policy, it's more likely protected. If it's domestic policy, it's more likely going to have to be disclosed. This is pure domestic policy. This is law enforcement. There's no foreign diplomacy involved or anything like this. It's domestic law enforcement. Laws were broken. Federal agents died. And there's no question that this was any sort of legitimate operation. So there's no grounds here. If you look through all the case precedents on executive privilege, Holder really doesn't have much of a leg to stand on. But I think he's going to try and take it because it's the only option he's got.
Yeah. It's interesting, Ken. I mean, we've already seen Eric Holder's Justice Department smacked down by the Supreme Court over what was the voting case? There was it was an 8-1 decision, right? That was last term.
That was actually year before that.
Last.
There'll be another big voting rights case coming up this year. There are a number of claims that the Holder Justice Department makes that I think that the courts are unwilling to buy, and that ranges on everything from voting rights to redistricting to we're soon going to see, I think, part of the Arizona immigration law. Yet another thing where they're making an argument where I don't think the court's going to buy it.
Right. So, Ken, what about the timing of all of this? I know that everybody, I think, except perhaps Eric Holder and Barack Obama, would like to see this investigation conclude as quickly as possible. It's been almost a year and a half now since the investigation began, and that really is, that's just exasperating. It's ridiculous considering the GSA scandal was investigated in less time. The Secret Service scandal in Cartagena was investigated in a matter of weeks. Here we are almost 18 months into the Fast and Furious investigation, and we still can't get the answers.
Well, that's right, Cam. Now, part of this delay is inevitable from a court perspective because the term we use is justiciable. The court does not hold that this kind of conflict between the political branches, Congress and the president, that it is ripe for adjudication, that it's something that the court should decide until it becomes clear that the political branches have exhausted every avenue of trying to work out some sort of arrangement. So the different rounds we've gotten of subpoenas and replies and testimonies and accusation, all of this stuff that, again, as you said, has gone on forever, is part of what the court looks to before they're willing to say, okay, now we're going to step in. It really has to get to gridlock. It has to get to an impasse where the court is satisfied that it is not the case if they just hold off another 6 months that the White House is suddenly going to make an offer that Congress will find acceptable. They have to get to the point where they're like, okay, these guys are no one's going to budge. This is
right.
This is just what it is, and that's when they come in kind of as the tiebreaker in our three-system form of government. That it's going to end up as 2 against 1 at some point. So that's where we're at now. The next step will just be ISA holding a committee vote on a contempt citation. And then the second question will be how quickly John Boehner, the Speaker of the House, is willing to bring that contempt citation to a vote on the House floor. Beyond that point, as soon as that goes over to the U.S. Attorney's Office, I'm not sure under law, I'm not sure if he has 30 days or 60 days or something like that to determine whether to prosecute, and I wouldn't be surprised if he waits until 11:59 p.m. on the very last day before shooting over an email saying, yeah, I'm not going to prosecute my boss's 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 boss. But after we get to that point, then the ball will be back in Speaker Boehner's hands in terms of how quickly he's willing to allow a vote to authorize Darrell Issa to file a lawsuit.
All right. Well, listen, Ken, I appreciate you joining us on the program tonight, sir, and look forward to having you back again very soon.
So thank you, Cam. Great to be with you.